All right. This is Module 7 of Legal Aspects of a Small Business, BA 121B. I'm Sarah Holtzclaw, and we are going to talk about intellectual property this time. So, our last disclaimer, there are intellectual property attorneys, so talk to them if you have any kinds of issues or questions. What is intellectual property? Intellectual property law tries to strike a balance between protecting the interest of an author or a innovator, a invention, with the wider public interests and their right to access that information. It's also trying to foster an environment where creativity and innovation can be rewarded so that it's not, and they rewarded both mostly financially to make sure that they have a right to their um, inventions, really, and their authorships. So we're going to talk about patents. We're going to talk about trademarks, copyrights, trademarks and service marks, and just a little bit about trade secrets. So this is just to show you, you've probably seen these. Not everything needs to have one of these, but the TM and the SM stand for trademark and service mark. Um, and if they're registered, then they'll have the little R with the circle around it. And we'll go through those. If it's copyrighted and registered copyrighted with the um, legal authorities, it will be with the C and a circle around it. But it doesn't have to have the C to be protected. Okay, so let's talk about patents. A patent is the exclusive rights granted to somebody for new and useful inventions. It's talking about the actual product that you have, not the name and things. That's under other trademarks and stuff, but it's the actual goods that you are um, trying to make um, and trying to protect. It provides the owner, the patent owner, the right to decide on how and whether that invention can be used by others. And it's important to know that it's not necessarily giving them the right to use it, it's giving them the right to exclude others from using it and selling it. So, and they're very territorial, so it's all within the United States. So, you know that we have a lot of issues with other countries creating something that we've already, the Gucci watches and the um, uh, iPods and Apple Watches and that sort of thing getting knocked off and made in other countries. So um, it is something that has been in our Constitution from the very beginning. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to the respective writings and discoveries. So it's been there since the beginning of our country. Um, and but our patents are only within our country's borders. Patents have to be for something that is new and useful, has to be for something that is useful, new, non-frivolous, and obvious, not an obvious type of thing. So you can't patent spoons, for example. You can't patent silverware or glasses because those you can redesign them and maybe and then have something on the design of it, but you can't patent just a spoon. Um, the most popular type of patents is the utility patent. That's up to 20 years. Um, and there you can patent the design of a particular type of, well, let's just say It's a water bottle. One of my favorite kinds of water bottles is called the Hydro Flask. And they're not patenting the water bottle, they're patenting their insulation type of ways to keep the water or coffee hot or cold. Um, and they can patent that design and make sure that others don't do it in a similar way. If you know the company Monsanto, you know that you can actually patent plants as well. And those are the years of which the patents are good for. So, just a quick thing about patent infringement and patent trolls. Infringement is the act of making or selling um, a patented invention, and there are multiple lawsuits over patent infringement. So, as I said, Monsanto can does a lot of lawsuits to individual farmers because the farmer is using their seeds without paying for the seeds. So, for instance, if they're doing corn that is Roundup resistant, um, the farmer can't use that corn seed the second year. They have to buy new corn seed. They can't reuse that corn seed. Um, so and Apple versus Samsung was a big lawsuit that Apple lost. And it's Apple lost. No, to be honest, I don't remember which one lost, but that was a big one. And Apple was suing Samsung because their products and their designs looked too much like an Apple phone. Um, their apps were rounded and their corners were rounded and that sort of thing. So, but they had to sue them in the United States. They couldn't sue them outside of the United States because the patents are different. Patent troll is somebody who will create a patent way beyond what is really there, and um, they can actually create a patent for something that they think might be invented and then keep others from inventing it, or charge them once they have invented it. It's crazy and it's happening a lot lately. All right, let's talk about copyrights. Copyright is a literary or artistic work that you are trying to protect. Um, Copyrights need to be a musical piece, books, paintings, sculptures, films, some kind of artistic work. They can be published or non-published, and they are issued by the U.S. Copyright Office. And they are actually created, that Copyright Office was created by Congress in 1897, and it's a branch of the Library of Congress. So, it basically is protecting the right of the author. Um, you've all been given warnings about plagiarism. It has something to do with that. It doesn't just have to do with I'm not selling the piece, so it can't be copyrighted, but you need to make sure that you are giving current the current author um, their due process. A lot of that, uh, the copying of music has to do with copyrights, making sure that you're not downloading video that you're not paying for, and that sort of thing. That's all under copyright law. Copyright, you can't copyright the name Delta. You can't copyright the name John Doe and that type of thing. You can't protect those because they are formal names. Okay, trademarks and service marks. A trademark is a word, a phrase, a symbol, or a design that identifies a good, and a service mark identifies the service rather than a good. So that's just really the difference. A trademark is identifies a um, it identifies the, let's just say, the restaurant itself. Um, and a service mark could identify the way that you give the service. It can be a slogan. It can be, um, let's just see, like "Lovin' It" by McDonald's. That could be trademarked. It's a phrase. It's the type of thing that the way that they put it onto the font style and their that kind of thing can be um, trademarked. Um, they they typically protect the logos and the brand names. Those things are usually there is both Secretary of State that you could file your trademark with, and the U.S. Patent and Trademark Office. So in California, you can actually protect it at a second level at the state. So there's a couple different things. Again, you generally cannot trademark or copyright a common word or a common name. So here's a couple examples. Delta, the word Delta can't be trademarked, but Delta Airlines can be. Delta Hotels can be. So Delta Airlines can trademark that within the realm of the airline industry. Delta Hotels can trademark that within the name of the hotel industry. But you can't just trademark Delta. Um, Disney's another example is Cinderella can't be trademarked. Now, the Cinderella's images, Cinderella's even the names of her stepmother and her stepsisters can be trademarked. The way that she looks, so you can't, for example, put your Cinderella in a blue dress, um, golden hair, and a headband, and a blue headband, just like Disney Cinderella. So you have to be very careful when you're stepping over these things. So Cinderella is in common in public domain, but you can't. But the way that Disney has gone about it. It came in because Disney sued the makers of Zombie Cinderella, believe it or not. Um, and it didn't fly. Um, Another example would be the word Super Bowl. They've actually trademarked the word Super Bowl, so you'll see in some ads that they'll call it the big game instead of Super Bowl, because the NFL has literally trademarked the word Super Bowl. Not just not just the way that they use it, but the words Super Bowl. Um, Another example, this isn't in the U.S., but there is a British grocery store, a frozen foods grocery store, and it's based out of England, but its name is Iceland, and they have trademarked that. And the country of Iceland is trying to sue for the use of the name Iceland in the European Union, because this grocery store is keeping the country of Iceland, believe it or not, from using their own country's name. Interesting. Here's another example. The band Train can't trademark the word train, but you can see from their album covers that they have a certain type style that they're using for their band. So that can be trademarked, um, but the word itself, train, cannot. Let's talk about trade secrets. Trade secrets is secret information that has some kind of economic value that if it got out, your company would lose something of economic value. And a trade secret can um, provide some kind of competitive advantage to that company. And it's actually treated, you have to treat that trade secret in a way that can reasonably be expected that you're preventing the public and your competitors from learning about it. So all of these companies that you see here, all of these logos that you see here have some kind of trade secrets. Some of the most famous are Coca-Cola, of course, their secret ingredient. You never has been kept in a vault for hundreds of years. Dr. Pepper actually has ingredients in it that they've never told anybody. Heinz 57 has nobody knows what those ingredients are, those 57 ingredients. Um, KFC has something in their spices that they don't tell anybody. Um, Interestingly enough, the Thomas English muffins are a trade secret. It's interesting. It says what's the nooks and crannies all about, but the way that they bake it and the way that whatever the ingredient is that makes those um, the English muffin the way it is a trade secret. WD-40, nobody knows what's in completely what's in WD-40 for to make it work. And believe it or not, the Google algorithms are a trade secret. They're treated like a trade secret. Nobody, they keep it so that you cannot um, copy it. This is one of my favorite trade secrets, but y'all know the Bush's dog, and they make a great deal out of it. They have fun with the fact that Bush's Beans has something in it that they won't tell about, they won't say. And of course, the famous dog that's always trying to get rich by knowing what's in the Bush's Beans and telling, make me an offer, meaning that I'll tell you. All right, that's it. That's the end of Module 7 of intellectual property. There is links, just like the others. There's links at the end of the module, lots of them to all of those, the patent office, the copyright office, and that sort of thing. Secretary of State, all of them. Use them to your benefit. If you have any questions whatsoever, give me a ring or text me or send me an email, and I'll be happy to help you out. Again, I'm not a intellectual property attorney, so make sure that you contact the appropriate people if you have any questions whatsoever. Thanks.